Howdy, this is David Groce, your Texas tax and lawman. Let's talk about a new tool in the estate planning arsenal, a deed on death. Last time we talked about the power of a beneficiary designation and how many people can plan a simple estate with only a beneficiary designation. However, in Texas, the probate court looks at all of our assets at death and divides them into two categories: probate assets and non-probate assets. Non-probate assets are any assets controlled by contract. The best example is a life insurance policy that says at death, pay X. Last week we learned that this was called a beneficiary designation. Assets with a beneficiary designation are by definition controlled by contract and do not have to go through probate. So that leads to the question, what assets are not controlled by contract? Generally, the answer to that question is real estate and personal property. Most folks figure that when they pass, their next of kin will just show up and come and get their stuff. And that is what usually happens. However, in regards to real estate, a next of kin cannot just take your house, your land, ranch, or retirement home. All real estate ownership is registered in the county and has to be changed in the county. For people with small estates, this necessitated writing a will. However, in 2015, the Texas legislature created Section 114 of the Estates Codes, which allowed us to write a deed on death. A deed on death is just what it sounds like. We prepare a written real estate deed that says, on death, I transfer my specific piece of real estate to a named beneficiary. Other states, like Arkansas, have had this provision for years. But for Texas, this is a new, helpful tool for many clients with simple family situations or small estates. So let's look at a simple case. Assume Grandma Jones lives off her Social Security and has only a bank account and her home. We know she could do a beneficiary designation naming her only son as the beneficiary on the bank account. But what about the house? Well, now she could complete a deed on death that says the house goes to the son on her passing. For her, those two things comprise a complete estate plan. From a practical standpoint, many lawyers think of estate planning like chess, but the real truth is that sometimes it may be simpler than we think. Let's just hope there's not a booby trap on the other side. Until next time, adios. Texas tax and lawman legal disclaimer. Hey, I'm a lawyer. You know I have to have some lawyer mumbo jumbo. This is a general information video, not client attorney privilege information. The content is information only and is not directed to any specific facts or circumstances and cannot be relied upon as a legal opinion, even though that would be nice and save you a trip to the lawyer. If you have a specific legal question, feel free to contact David Groce directly or seek qualified legal or tax counsel in your state of residence, state of mind, or whatever place you call home.